there's an old rule of television, which is never follow cute children or animals, and the kind of corollary rule is never follow Michael Cohen, right? There's just no way we can match what you just saw, but I'm just delighted to be moderating this next panel, which I actually think is one of the kind of existential legal questions that we're trying to think through. And the issue is, can the 14th Amendment stop Donald Trump? And I cannot praise enough the two thinkers and scholars we have with us today. Burt Neuborne is the Norman Dorson Professor of Civil Liberties and founding legal director of the Brennan Center for Justice at NYU Law School. Burt has been, this is no exaggeration, one of the foremost civil liberties lawyers in the United States, serving as National Legal Director of the ACLU, Special Counsel to now Legal Defense Fund, and is a member of the New York City Human Rights Commission. Sitting right next to him is Noah Bookbinder, who became CREW's president in March 2015. Before joining CREW, Noah served as director of the Office of Legislative and Public Affairs at the U.S. Sentencing Commission and as chief counsel for criminal justice for the United States Senate Judiciary Committee. And I just want to offer one precatory note, which Noah can amplify, which is that CREW is responsible for the Colorado suit that is really going to be the test case. And as good news as that is for us who are with him today, it means that he is subject to a protective order. So he can't discuss some parts of the Colorado lawsuit in detail. He will do his level best to elide the boundaries of the protective order, but it just puts him in a position that we wanted to just be transparent about. I'm going to just read the disqualification clause for a second so that we are all on the same page. Section 3 of the 14th Amendment holds, quote, "No person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any states who, having previously taken an oath as a member of Congress, an officer of the United States, or as a member of any state legislature, or as an executive or judicial officer of any state to support the Constitution of the United States, shall have engaged in," here's the money quote, "insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such disability." So that's many, many words. And Burt, I wonder if you would unpack for us what the relevant parts of that are, and maybe more urgently, tell us the history of why that got popped in and what it was meaning to solve.
Sure, Dahlia. The 14th Amendment, as many of you know, was the centerpiece of the Reconstruction policy by the Republicans after the Civil War. The first thing they did is they put the 13th Amendment through, which ended slavery. That was in 1865. In 1868, the 14th Amendment went through, and that provides for equal protection of the laws. It provides for due process. It guarantees black people's citizenship. And Section 3 was put in there, frankly, to prevent Robert E. Lee from returning as a senator from Virginia. What they were afraid of is that when the southern states rejoined the Union, the leaders of the Confederacy were still regarded as political heroes in the South, and they would have undoubtedly, if they wished, had been able to resume powerful political careers and return to Congress and return to Washington as representatives of the South. And it was a pillar of Reconstruction politics to see to it that the people who led the Confederacy not only lost all their property, but lost their civil and political rights as well, and could not come back to Washington to haunt the new government as it attempted to carry out some form of racial justice in the South. So that's where it comes from. It's designed to prevent the people who led the rebellion, the Confederacy, from remaining in power once the southern states rejoined the Union.
And Noah, I wonder if you can just catch us up briefly on how it has played out, both historically at the time that it was drafted, and maybe, I know there's been a kind of interregnum, but we've certainly seen it playing out in recent years post January 6th. So can you just give us a very quick and dirty history of how it's been deployed?
Sure, thanks Dahlia, and it's great to be up here in such impressive company. And I will also just kind of apologize in advance. I think it's actually a very good thing in our litigation that there's a protective order that is there to really ensure the safety of litigants and attorneys and court staff, and so that was sort of a victory getting that there. It also means that everybody involved, including me, has to be a little bit more cautious than I would otherwise be. So that's a good, lawyerly bit of coverage before I say anything. So in the wake of the passage of the 14th Amendment, which Burt, I think, really effectively it kind of explained the context of, a couple things happened. One thing is that most people simply understood that this was now the law, and those who would have potentially tried to take office just didn't. So there weren't a ton of cases in the wake of the adoption of the 14th Amendment, but there were some. And there were actually, I believe, 7 cases, reported cases of officials who were removed under Section 3 of the 14th Amendment, or were prevented from taking office. They were not, all high-level people. They were not all people who engaged in violence. There was somebody who served as a sheriff in the Confederacy, and there is some case law from that period that we can draw on. And then, we had 150 years where we didn't have any insurrections in this country, which is a good thing. And then we had January 6th, 2021. And there, in the wake of that, has been one instance in which a court did remove an official under Section 3 of the 14th Amendment. That's a case in which CREW, our organization, represented residents of New Mexico who sued to remove from office a guy named Couey Griffin, who was a county commissioner. He was the founder of a group called Cowboys for Trump. He was somebody who recruited and organized for January 6th. He was on the steps of the Capitol encouraging people. He was not personally violent. And the court in that case found that January 6th was an insurrection for the purposes of the 14th Amendment, and that this person had engaged in insurrection, and he was removed from office, and he is out of office and enjoined from going back into office. And so that sort of gets us to the current situation where we're representing plaintiffs in Colorado, attempting to enforce what we believe to be they believe to be Donald Trump's disqualification from the 14th Amendment. I guess I'll stop there and pass it on back to you.
Let me ask you, before we get to enforcement mechanisms, because I think that's the sticky wicket here, but I want to ask you, just as lawyers, what do we do with the fact that the president may or may not be swept in under this? And there's an awful lot of folks that say many other office holders, not the president. And whether we really feel that we want to call this an insurrection or aiding and abetting. So just purely on a sort of parsing of the language of Section 3 before we get to enforcement, does Donald Trump qualify, yes or no? And was this an insurrection, yes or no? Maybe Burt, you go first.
I think the answer is, at least for me, it does cover the presidency. It doesn't explicitly say the presidency, but if you listen closely to the words that Dahlia read, it's a comprehensive effort to describe virtually every political office that exists in the system. And it is possible to parse the language and find a little teeny loophole that says that, it doesn't say president, but it does say office under. And it seems to me highly unlikely that they intended to say Robert E. Lee couldn't be president, couldn't be a senator, but he could be the president. So I think that argument doesn't go. The insurrection question is a little closer. They use the word insurrection or rebellion. So if the word rebellion weren't in there, I would be tempted to say that insurrection requires a level of violence that perhaps the January 6th didn't meet. It was a mob, and there was some violence, but there wasn't sustained armed violence the way you might expect an armed rebellion to be. But the word rebellion is in there. So insurrection has to mean something else. And so I think there's a plausible argument that what happened on January 6th was an insurrection, and the key question is Trump's responsibility and participation in the insurrection. And that, as Dahlia points out, is one of the enforcement issues that we'll have to talk about. How do we decide whether Trump is guilty of insurrection? Who does it? But I think the legal argument is there under the words of the provision.
How about you, Noah? Different thoughts or the same?
I mean, certainly on the officer part, the same. You know, I will again say I'm going to need to be restrained on legal issues that are going to come up in our case. I will say that on the insurrection issue, if you go and look at the judge's decision in the Couey-Griffin case in New Mexico, there's, I think, really pretty remarkable discussion of why that judge concluded that the 14th Amendment, the January 6th events and the lead up to that did constitute an insurrection for the purposes of the Constitution. And it's something that, you know, the Select House Committee, which reached the same conclusion, had a really comprehensive explanation as to why they reached it. In our complaint in Colorado, we also set out point by point, you know, why we believe that to be the case. It's a position that, you know, some really prominent scholars on all sides of the ideological and political spectrum have reached.
So probably folks know that there has been a kind of dispositive, definitive law review article written by Will Bode and Michael Stokes-Paulson called The Sweep and Force of Section 3, and everybody got very excited, or as excited as you can get about a law review. And as Noah has just suggested, we have Michael Ludig on one side and Lawrence Tribe on the other, all agreeing that this is completely applicable and necessary, in fact. But one of the things they say in their article is that not only is Section 3 very much applicable, it's self-enforcing, right?
Yeah.
And so I want to talk about the enforcement problem because it's the wonkiest part, but it's the trickiest part.
It is the wonkiest part where, so that's why I feel most at home, saying things that nobody will listen to but me. But the idea of whether or not a provision of the Constitution is self-enforcing is a really hard legal issue that comes up to the Supreme Court all the time. You might think that all you need is to point out a provision of the Constitution and say, that's the law, everybody has to abide by it, and I can enforce it in court. But that's not what the court has said over the years. The court has said some provisions of the Constitution are automatically self-enforcing, but others require a congressional trigger. Congress has to create the means of enforcement. And if Congress doesn't create the means of enforcement, then the provision is unenforceable. And Congress has never enacted an enforcement provision for Section 3 of the 14th Amendment. So for just two quick analogies, the Constitution lays out the jurisdiction of the federal courts. It says what kinds of cases federal courts can hear. And you might think that means that the courts can hear those cases. But the Supreme Court has said, no, there has to be some congressional action that triggers the enforcement of that. Same thing with damage actions. If you violate the Constitution and sue for damages, the Supreme Court has said you have to have a congressional authorization. And I'm afraid that the enforcement mechanism of Section 3 of the 14th Amendment is sufficiently complicated and requires sufficient affirmative action by a number of officials that the Supreme Court could potentially say, no, it's not enforceable because there's been no congressional authorization. That's what Salmon Chase held. He was a Supreme Court justice. A year after the enactment of Article 3, he ruled that it was unenforceable in Griffith's case because Congress hadn't yet passed any enforcement mechanism. Now, other circuit justices disagreed, but I'm afraid that that's a major obstacle to the use of the 14th Amendment now.
So I'm going to guess, Noah, based on the fact that you just described the New Mexico suit and you're involved in the Colorado suit, that you in fact disagree with Professor Neuborne and that you think it is very much enforceable. And I'd love for you to the extent that you can kind of find light between what the two of you are doing and also comment on it, tell us why it is enforceable in the absence of a congressional enactment.
Yeah, and obviously this again is a key issue that is going to be litigated, and so again I'm going to be a little bit restrained and mostly sort of point people to some places where they can look for I think a pretty different conclusion, and you know, starting with you know, it is true that Justice Chase wrote the decision that Burt talked about. He also I believe it was within a year. Wrote a different decision, actually in a case that touched on Jefferson Davis himself, I believe, where he found that this provision was self-executing. So, you know, that's, you sort of query in some ways how useful his commentary on the matter is, since he's pointing in a number of different directions. There certainly are cases both from the 1860s and from New Mexico last year that came to the conclusion that this was self-executing. That's certainly where Professors Bowd and Paulson come out, and Judge Ludig and Professor Tribe. And I guess I would put forward that an appropriate analogy could be, you know, less provisions which seek kind of penalties or punishments. You know, I think we would argue that this is not a penalty or a punishment. This is a qualification. And you know, the Constitution has other qualifications for president. You got to be 35 years old. You got to be a natural-born citizen. And there's a lot of case law saying that courts can enforce those qualifications. There's actually a 10th Circuit case written by then Judge Gorsuch that finds that point. So, you know, this is certainly something that's going to be litigated. You know, there's I think it is a thorny issue, but I think there are a lot of places you can look for pretty strong support for a finding that it is self-executing.
Burt, I want to circle back to something you said, which is there's also a real question as to Trump's conduct, whether what he did rises to the level of fomenting an insurrection or a rebellion or aiding and abetting. And I want to ask that question, but I want to ask it in the guise of we're already seeing in Noah's lawsuit a sort of blanket First Amendment defense, right? So unsurprising, because there's always a blanket First Amendment defense in the law of Trump. But what do we think about the fact that in the end of the day, he's going to say these were just some words?
Well, that's a very important issue that's going to come up. The New Mexico case, I mean, it's a little, I understand what Noah's doing, and I really appreciate the amount of effort and energy and sheer lawyerly brilliance that's going into these cases. But it's an awfully big stretch to rest on a single judge in New Mexico deciding a case about a local office and generalize from that you can disqualify somebody from running for president. The enforcement mechanism about whether or not Congress has to step in is complicated here by the fact that while that New Mexico official was guilty of being standing on the steps of the Capitol and perhaps giving aid and comfort, which is part of the language, to the people that were going in. Trump never went to the Capitol. He does what he always does. He gets other people to do his dirty work for him, and then tries to hide behind technicalities when someone tries to hold him responsible. So this is a situation where Trump's guilt, if it is guilt, is based on his words. It's based on the speech he gave to the demonstrators. It's based on the various speeches that he gave in the months leading up to the election, whipping up a frenzy that was likely to, or at least potentially likely, to overflow into violence, and did. And the question of whether that constitutes an insurrection that disqualifies you from running for office is a very dangerous idea. How many radical speakers in American history have given profoundly disquieting speeches urging people to action, and then the action actually takes place? If what we want to do is to say that every speaker who urges people to engage in behavior that is ultimately illegal, and that somehow interferes with someone's idea of the orderly functioning of democracy, is disqualified from political office, then we're opening a Pandora's box that we just don't want to do. Because the danger to First Amendment freedom, I think, is very serious. Now, I think Trump is not protected by the First Amendment, but I would be nervous about saying that what we can do is punish him by disqualifying him from ever running for office again.
Noah, do you have different thoughts on the matter?
So here I have to be particularly careful. I think this is the area in some ways where I most can't wade into the facts, and I'm also also a little nervous about wading into the First Amendment next to one of the preeminent First Amendment practitioners of our time. So I'll point to other people and say, in that New Mexico case, which believe me, I very much understand that there is a tremendous difference between a case involving a county commissioner and a case involving the then president of the United States. Although I think in a situation where there are relatively few precedents to look to, it's an important one. But in that case, there was an amicus brief submitted by a number of the leading First Amendment scholars, a number of the other leading First Amendment scholars of our time. Larry Tribe and Floyd Abrams and Martha Minow and I believe Erwin Chemerinsky was on that, explaining in some detail why the kind of conduct at issue in that case, and understanding there are some distinctions here which can point in a lot of different ways, but was not excused by the First Amendment. That's something that Professors Bowden Paulson, as I said, Professor Tribe and Judge Ludig that's a case that they have also made in the context of Donald Trump. So there are certainly places that you can that you can go to look for why that the First Amendment might not provide a problem here, keeping in mind that the 14th Amendment is also part of the Constitution. So this is not a question of do you have a statute that is that goes against a part of the Constitution. This is how do you reconcile two different parts of the Constitution. And the one we're talking about, again, as I said, is not a punishment, it's a qualification. I should probably leave it there as to that issue.
We're going to leave it there only because we have a big 0-0 on the clock in terms of our time. I do want to just note that one of the issues that we can think about from the first half of this particular conference and the second half is this undergirding issue of politicizing versus judicializing Donald Trump and the fight against Donald Trump. And it's a really interesting problem. A lot of the folks, I think, who are, share some of Burt's concerns really don't think this is an issue that should be solved by the courts. They think it should be solved by politics.
Well, I think if you're going to defeat him, We have to defeat him at the polls. There's no silver bullet that's going to take Donald Trump out of our lives unless we organize and defeat him at the polls. If we disqualify him, it's going to be like the dog that caught the car. What are we then going to do with him? We're going to have a nation of civil strife. So please don't put your eggs only in the legal basket. Don't become addicted to the courts. Politics is the only way we're going to defeat Trump.
I'm going to let Noah speak on behalf of the dog, who may or may not catch the car, and I understand you're constrained.
Yeah, I mean, I guess what I would say is that we are working in the context of recent history, where I think in the 2020 election and the aftermath of the 2020 election, we saw some of the limitations of relying entirely on the political system. We have a constitution. The Constitution sets out the rules for our democracy. The Constitution is not optional. It's not something that we apply when it suits us, when it kind of seems strategically advantageous. The Constitution sets out the rules of this system that we live in, and it has rules like this one that were specifically put in there for the preservation of democracy. I would suggest that it's in the interest of democracy that we not forget about or ignore what's in our Constitution.
Please join me in thanking Burt Neuborne and Noah Bookbinder, both of whom, without exaggeration, are heroes of our democracy. Thank you.
Thank you so much, Dahlia.